to your question, Your Honor, harassment
This
and
is a
conduct,
public
not
service.
speech. I have copies of Arizona Court of Appeals cases, State v. Brown from 2004 and State v. Snyder from 2024, further explaining that if the court would like to review those. I'm not asking the court to restrict Mr. Myers' speech on political matters or general topics, but Mr. Myers has harassed me personally and posted videos about me on his YouTube account. In those videos, he has posted my place of employment, work email and phone number, and office number, and asked his online followers to harass me as well, which they have done many, many times. Thank you. Email office number encourages his followers to come visit me and says anyone can come visit me, and obviously visited me himself.
And does he say why they should come visit you?
No, my impression has been that it was all so that I could be intimidated and by extension my husband out of no longer prosecuting his case.
And from your perspective, is there any reason that Mr. Myers should be having any sort of contact with you?
Absolutely not.
And have you ever told him to stop having contact with you?
We've never spoken. I've been afraid of him. We've never spoken. I've been afraid of him.
All right, we are back on the record. Thank you everyone for your patience. All this paperwork is now online, and I'm not the best typist, so that's why it took me a little while. What I'm going to do now is tell you what I'm going to do generally. I'm going to explain why I'm doing it. When I'm done, I'll see if anybody has any questions or wants to make more of a record. I'll start with the plaintiff and then we'll go to the defendant. Here's what I'm going to be doing. I'm going to be affirming the injunction. I am going to be modifying it, however, and I'll talk about the modification and why I'm modifying it in a minute. In terms of my findings, I am finding that the plaintiff is credible and she is believable, that she definitely feels like she's being harassed. I found everything that she told me, not only about her feelings and what she's going through, but also just the facts, her summary of the videos. I'm finding that she's all credible there. I don't feel the need to look at the videos. I think both the parties have told me about them. As for the defendant, I am not finding him credible. I do not believe much of what he said. In particular, when he laughed, in my opinion, and I'm finding that he laughed and was excited about the voicemail from the third party and the awful things that were said about the plaintiff.
Objection, Your Honor.
You can't object to what I'm saying.
I can do whatever I want.
Actually, no, but it is rude. I'm just explaining myself.
You're being rude too, gaslighting me by telling me what I meant when I told you my girlfriend texted
I'm
me.
giving you a chance later to talk about it. I'm making a finding of fact. That
It's not a finding of fact, it's a finding of opinion. It's literally called an opinion.
Well, we'll disagree on that. So those are my credibility determinations. I am finding that there are a series of acts. I think the first voicemail from the defendant qualifies. The YouTube videos qualify. I believe the defendant was encouraging third parties, directly or indirectly, to make the calls. And I think going to the work was another act. Finding that I referenced the statute earlier, ARS 13-2921.
Doesn't apply.
Please stop interrupting me. I will give you a chance.
Quit gaslighting the people, sir.
I will give you a chance to make the record. The statute talks about contacting or causing a communication. I believe and I'm finding that the defendant has caused third parties to communicate with the plaintiff through those YouTube channels.
That's going to get overturned on appeal.
By explicitly and encouraging them to contact her. Cases that support that are King versus Seba, S-E-B-E-A, 2012 Westlaw 209751, paragraph 25. That case talks about a defendant who made calls to building employees and others with the
Calls, not call.
with the intent to
Calls, not call.
Sir, if you interrupt me again, I'm going to ask you to leave.
I'm about to leave. Voluntarily.
You're not going to get a chance to make your record.
You're getting overturned on appeal whether I do or not.
So you've been warned. If you
You've been warned you're getting sued too.
All right, I'm asking you to leave.
Thank you.
Thank you.
So that'll be posted on, somebody will mail it to me or something?
We're going to give it to you right now.
Cool,
Just
thank
sign
you.
right here for me saying that you got it. Sign this right here saying that you got
Right
it.
here? Cool. You guys can talk amongst
Do you want
yourselves.
Do you want your disc, your little flash drive back?
I thought it was on the record for appeal.
Hold on, let me check. Maybe I misunderstood. Oh,
Signature and here's your exhibit.
sign here. and
Why
then
is
take
my
your
exhibit not being turned in for the appeal? That's what we turned exhibits in, for the record for appeal.
You've lost your chance to be here. You keep interrupting me.
That doesn't mean I lost my chance to put an exhibit on the record.
If you want to go outside
Just
and
sign
come
this
back
right
in
here.
5 minutes after you calm down and follow the rules, I'll let you. Right now, you're not following the rules. You need to leave.
It's your choice.
Should you want me to leave my stuff here?
You want to come back in 5 minutes?
That needs to be, yeah, sure.
All right, go outside.
Turn
calm
off
down.
your.
I don't need to turn off my recording.
Yeah, it has to be on your person.
Then I'm not, then I'm just leaving. What am I signing?
Sign right here.
If this isn't on the record, you're getting sued, you know that. So I'm gonna leave it right there. You don't get to tell me I don't get to put an exhibit in because I hurt your feelings, Your Honor.
Put behind your.
See you in court, Your Honor. I'll be filing the appeal when I walk downstairs. Notice of appeal will be filed when I get downstairs and the special action against you. So is that getting in, or I need to put a special action on that too?
Please leave, sir.
Is that being taken into evidence or not?
You are violating a court order right now by not leaving.
Hold me in contempt, bro. I dare you.
By calling me bro is very disrespectful. By cussing at me and throwing things at my staff. All right, if we can have the minute entry note that the defendant has left. If the minute entry could note that on his way out, the defendant repeatedly cussed at the judge. If the minute entry could note that the defendant threw, what is that called? A flash drive towards my staff. If the minute entry could note that the court repeatedly ordered the defendant to leave after warning him that he wasn't following the rules. He failed to do so, continuing to violate a court order. I'll now continue to explain my thought process. I'll add to the credibility determinations the defendant's conduct on his way out lends to my credibility determination about him that I do not find him credible at all. The other case that supports my application of ARS 13-2921, I think is State versus Snyder. That is 2024 Westlaw 342301, and specifically paragraph 16. That case talks about the defendant posting videos, and talks about several people contacting the plaintiff about the videos posted by the defendant, and talks about holding the defendant responsible for the resulting communication of those third parties not being so extraordinary that it would be unfair. So I think that case supports my factual findings. I do think that all of these acts that I've mentioned were directed at the plaintiff. I can totally understand why she is alarmed, scared. I think not only a reasonable person would be, but I think almost any person would be. I think it'd be unreasonable not to do. I'm finding that there's no legitimate purpose for any of these acts, and in fact, I'm specifically finding that I think the defendant's purpose is specifically designed to harass and bug and annoy. And I think his conduct during this hearing has confirmed that. That said, the order that I've sent, and we'll make sure that the plaintiff gets a copy of the order that I've signed, does affirm that the defendant is to have no contact with the plaintiff, not to go near a protected location. The other orders is what I've changed. The defendant must have no direct or indirect contact with plaintiff through any form of social media. That was basically in there before. The defendant must not post or place plaintiff's contact information, including her work information, on any social media platform. Defendant must not, through social media or otherwise, directly or indirectly encourage third parties to contact plaintiff or to go to a protected location. What I'm trying to do there is balance the defendant's constitutional rights with the right of this plaintiff not to be harassed. I think I've done that. I've tried to do that. We'll just note that I was going to give the defendant an opportunity to hear those restrictions and convince me if I should do something else, put different wording in there. He has chosen not to participate anymore in the hearing, so to the extent he had any insight on that, we don't have it. We don't have the benefit of it. Ms. Walker, anything I'm missing, more of a record or findings that you want me to make?
One thing that, Your Honor, I have wondered about, just that goes to my fear of Mr. Myers, is that I don't believe he's been ordered to not have any weapons. I don't know if that's something that can be considered, but that's something that was not part of the original injunction against harassment.
I didn't hear any testimony or evidence about guns or flashing guns or anything like that. I'm reluctant to do that without that sort of...
Okay, I understand.
I hope it doesn't happen, but if it does happen, feel free to come back and ask for a modification.
Okay, thank you, Madam.
Anything else that you want to do? Any other findings that you think I should be making? If we anticipate the appellate court is wondering what I did and why.
Your Honor, I do have a question about the current videos that are still displayed on Mr. Myers' YouTube channel that violate this. I understand that things that are outside of protected are not considered, but he has violated this probably more than a dozen times with additional social media content. Is there any sort of consideration for him to be required to take those videos down that do display my contact information? Because unfortunately they do continue to encourage people to reach out to me as recently as today to harass me.
I'm thinking.
Of course. Thank you.
It must be a first.
I did know that I have the authority to do things that happened already from a First Amendment standpoint. I'm by no means a First Amendment scholar, or although I do dabble in it, I'm interested in it. So I don't feel comfortable doing that in past tense as opposed to going forward.
I understand. Thank you for considering.
I wish I could do more for you. I apologize.
You have nothing to be sorry for.
All right.
Thank you so much for hearing me today.
And if you think there's more I can do from a constitutional standpoint, file something, file a brief, give me the cases, ask for a modification, and I will listen. Okay. With both ears.
Thank you, Your Honor.
Thanks, everybody. Have a good one.
We're out here today to ensure our natural rights are respected by those who swore an oath to support, protect, and defend the rights of the people. The purpose of all interactions is to peacefully promote government accountability and transparency. Please like, share, and subscribe so this message can reach as many people as possible. I implore you to peacefully seek redress to any and all of your grievances. This is a public service.